Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Welcome to Episode 8 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we're covering cases decided between August 5th and August 11th, 2020. We'll start with a civil procedure case. In the case of Satiro versus Maninno, the court addresses preservation of issues for appeal when a pro se applicant files the appeal. In this case, the issues arose from an attempted sale of a business. The contract for sale failed necessarily because of the prior lease agreement. The appellant filed an appeal pro se, raising 29 issues. However, he failed to concisely identify each ruling or error that he was challenging. As such, the trial court had to guess at what issues were being addressed. Ultimately, because he failed to concisely state the issues on appeal, the court found that all issues presented were waived. The court declined to offer any special treatment to an appellant simply because they filed the appeal pro se. Up next, we will address criminal cases. Commonwealth v. Bradley is a criminal case that evaluates eligibility for the Recidivism Risk Reduction Incentive Act, or J.R.A. Bradley raised issues of the discretionary aspects of his sentence, but the court found that because he did not raise the issue at sentencing or in his post-sentence motion, the matter is waived for purposes of appeal. The only issue decided by the court is J.R.A. eligibility. The J.R.A. statute provides that an offender that demonstrates a history of present or past violent behavior is not eligible for J.R.A. Bradley has a single prior conviction for disorderly conduct, and the trial court found that was sufficient to deem him ineligible for J.R.A. Here, the court found that when a defendant is being sentenced for a non-violent crime, as is in the case here where the defendant is being sentenced for theft crimes, his single prior conviction for a non-enumerated crime of violence does not alone constitute a history of past violent behavior as to trigger ineligibility for the J.R.A. program. As such, even if the disorderly conduct conviction is a crime of violence, the single conviction is insufficient. The court vacated the judgment of sentence and remanded to the trial court with orders to sentence the defendant to the J.R.A. minimum. Commonwealth v. Webb is a post-conviction relief act case. In this case, the defendant was convicted of third-degree murder following a jury trial. The basic facts are as follows. On May 17, 2014, at approximately 1:30 a.m., the victim was leaving the Beer Barrel Bar, walking through a parking lot when 3 shotgun shots were fired. He was hit with shotgun pellets and died shortly thereafter. An eyewitness to the shooting claimed to see the defendant standing outside a car and raise his arms up like he was raising a gun. She ducked, and then she heard a gunshot. Later, when she was interviewed by police, she picked defendant out of a photo array. Another witness, a jitney driver, testified that she picked up the defendant, drove him to the bar, and while waiting in the car outside the bar, the defendant jumped out with a gun, shot 3 times, and then jumped back in the car and said, "That's what you get for killing Chauncey." During the trial, the first witness testified about how she was placed in the witness protection program, and there was evidence presented through testimony of the jitney driver that the defendant was a low-level drug dealer. The defendant, in his PCRA petition, claimed ineffective assistance of counsel for allowing these items to be presented at his trial. The PCRA court dismissed the petition without a hearing, and this appeal followed. The Superior Court found that there was no ineffective assistance of counsel as the record supported the strategy of the attorney and the defendant was unable to establish prejudice, meaning a showing that but for the attorney's ineffectiveness, the outcome of the trial would have been different. The court stated, "We find that what is ultimately detrimental to defendant's claim is the overwhelming evidence of his guilt introduced at trial." The court found that the PCRA court did not abuse its discretion when dismissing the petition without a hearing and affirmed the ruling of the lower court. In the criminal case of Commonwealth v. Jones-Williams, the court addresses circumstances in which a warrantless search of a driver's blood in a suspected DUI case may be obtained. In this case, appellant was the driver of a vehicle that was involved in an accident with a train. Following the accident, one of his passengers died, and he and the other passenger were transported to the hospital for emergency treatment. On the scene, it was reported to officers that there was an odor of marijuana. An officer was sent to the hospital to interview the appellant and request a blood sample. The appellant was in and out of consciousness and unable to participate in the interview. The officer learned that the hospital had drawn a blood sample prior to the officer arriving. The officer then requested that the blood be sent to the lab for testing for alcohol or controlled substances. The officer did not obtain a warrant. There's a statute that allows a hospital to draw blood when they have probable cause to believe that a person was DUI. However, following the Supreme Court decisions in the Birchfield case, the court concluded that the statutory exceptions are not sufficient to overcome Fourth Amendment constitutional requirements. The appellant had filed a motion to suppress the blood results, which was ultimately denied by the trial court. However, in its 1925A opinion, the trial court concluded that they erred when not granting the suppression. This instant case arose after conviction at trial. The court concluded that statutory implied consent cannot take the place of voluntary consent. In order for the Commonwealth to request a driver's blood result, it must obtain a warrant or it must proceed with a valid exception to the warrant. If government officials rely on a driver's consent, they must demonstrate that the consent was voluntary, meaning he had a meaningful opportunity to make a knowing and conscious choice of whether to undergo chemical testing or exercise his right of refusal. In this case, voluntary consent was not shown. Additionally, the court found that the exigency exception to the warrant requirement did not apply in this case as the blood had been drawn prior to the officer's arrival and had already been preserved. There was therefore no exigency excusing the requirement to obtain a warrant. The judgment of sentence is vacated and the case is remanded for a new trial. In the case of Burns v. Cooper, the court addresses a defamation claim. The plaintiff and defendant in this case were married and going through a divorce. While the divorce was pending, the plaintiff took a trip to see her dad in Washington, D.C. She brought several items of value, including a Louis Vuitton bag and some jewelry, as she was fearful that the defendant may try to steal it while she was away. When she was in D.C., her car was broken into and the items were stolen. Plaintiff then made a claim with her insurance company. As plaintiff and defendant were both on the insurance policy, the defendant was required to join the claim. When interviewed by an insurance representative, the defendant stated that he didn't believe the theft occurred, that the plaintiff was a liar who could not be trusted, and he would not sign the claim. This resulted in a fraud investigation being opened against the plaintiff. Plaintiff was required to take time off work and pay for a lawyer. Plaintiff sued the defendant for defamation and tortious interference with contract. After a jury trial, the verdict was announced in favor of the plaintiff and she was awarded $75,000 in damages. The defendant appealed, claiming that the trial judge erred by failing to establish prior to trial that the statements were capable of being defamatory. He also claimed that there was insufficient evidence for the jury to find that the statement was actually understood as defamatory. Here, the court found that the judge did in fact establish that the statements were capable of being defamatory and noted as much in granting the plaintiff's motion for summary judgment. Further, the court found that the jury could reasonably decide that the insurance company, as the recipient of the defamatory statements, did understand them as defamatory and therefore the verdict should not be disturbed. The judgment in favor of the plaintiff is affirmed. We'll be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
Welcome back. The next area of law today is family law. The case of E.K. versus J.R.A. involves both a protection from abuse case as well as a custody matter. Mother and father had 2 children together. They were together for 17 years but never married. After they split up, there were a number of PFA petitions filed as well as a custody matter. The PFA order and custody order that are at issue in this appeal came about when, after a custody hearing that eliminated father's time with daughter and only allowed for supervised visits with son, father put up a Facebook post that was threatening in nature to mother and to mother's attorney. Mother then filed another PFA petition. At the PFA hearing, mother testified to the prior 17 years of abuse. Father did not deny any of the allegations. Following the hearing, the court granted the PFA petition as to the mother, her children, her boyfriend, and her place of work. The court also, sua sponte, meaning on their own without either party requesting such, held the father in contempt of the custody order and sentenced him to 6 months in prison until he wrote in his own hand how he intended to comply with the custody order. On appeal, the father contests both the PFA order as well as the custody contempt order. As to the PFA hearing, the Superior Court found that the mother's testimony about the history of abuse was enough to establish by a preponderance of the evidence that father's Facebook post placed her in imminent fear of serious bodily injury, and therefore found no abuse of discretion in granting the PFA. The court also found that it was proper for the protection of mother to include the children, her boyfriend, and her place of employment. As to the contempt order, the Superior Court addressed what is required in order for a court to adjudge a person in contempt. There are recommended elements to ensure due process, but all that is required is notice and an opportunity to be heard. In this case, father was not on notice that a contempt hearing would be held, as the judge sua sponte found father in contempt during the PFA hearing, which was not about the custody order at all. Further, the judge did not allow the father the opportunity to be heard. Therefore, due process was violated and the contempt order was vacated. The next area of law today is property law. Carunchio et al. Versus Swarthmore, Borough, and Headstrong Foundation is a property case addressing accommodations to zoning ordinances. The Swarthmore Borough granted the accommodation to Headstrong, and the appellants brought this appeal. Headstrong owns a 7-bedroom, 2.5-bath property that is located in a single-family dwelling zone. Under the ordinance, family is defined as no more than 3 unrelated persons living together. Headstrong is seeking an accommodation to the definition of family under the ordinance because they wish to use the property as a facility where up to 7 unrelated cancer patients and their caregivers can reside while undergoing treatment. Under the Fair Housing Accommodations Act, the party seeking the accommodation bears the initial burden of showing that the requested accommodation is necessary to afford handicapped persons an equal opportunity to enjoy a dwelling. And then the burden shifts to those opposed to the accommodation to show that the requested accommodation is unreasonable. Here, the court found that Headstrong established that the accommodation was necessary, and no evidence was presented to establish that it was unreasonable. The next issue addressed by the court was whether or not the intended use as a temporary residence for cancer patients and caregivers meets the definition of dwelling as required by the ordinance. The appellants contend that a dwelling requires more permanent use, and the temporary nature of use as intended by Headstrong was insufficient to be considered a dwelling. The court found that a dwelling is a building or portion of building used for human habitation by a family. There is no ordinance or law that limits habitation by duration or permanency. Therefore, the court found that the intended use meets the definition of dwelling. In considering all the arguments, the Commonwealth Court found that the Borough Council did not commit any error, and it was proper to grant the accommodation to Headstrong. The opinion of the Borough Council is affirmed. In the property case of Guiser versus Sieber et al., the matter at issue is the trial court's order issuing an injunction prohibiting the landowner from blocking access over Woods Road, which the appellees claim they have a right to access. The first issue addressed is whether the court had jurisdiction to hear the matter. The appellants filed a post-sentence motion, but filed their notice of appeal before the post-sentence motion was ruled on and before the 120-day time period expired. For that reason, the matter is not yet ripe for appeal, save for the issue of the injunction. Orders enjoining conduct previously permitted or permitting conduct not previously permitted are immediately appealable. In evaluating whether the injunction was proper, it must first be settled whether the road in dispute was a public or private roadway. Because the trial court failed to determine whether the roadway was public or private, the Superior Court could not make a determination on the injunction. The case was remanded to the trial court to decide if the roadway was private or public. The last 2 cases today involve torts liability. In the case of Dobransky versus EQT Production Company, the court addresses whether or not a truck driver who delivers products to a drilling site is considered a statutory employee for purposes of the Workers' Compensation Act. If a worker is deemed a statutory employee, the employer is immune from tort liability. In this case, plaintiff was a truck driver who delivered materials to a drill site. He was responsible for delivery and then depositing the material into a storage tank. During one such delivery, the cap of a storage tank blew off and he was exposed to the material, resulting in injury. He sued EQT Production Company for compensation for his injury. EQT claimed that they were immune from liability because the plaintiff was a statutory employee. The Workers' Compensation Act considers a subcontractor a statutory employee if they perform work consisting of the removal, excavation, or drilling of soil, rock, or minerals. The court found here that the plaintiff did not remove, excavate, or drill for minerals, but simply transported and unloaded materials to the site. He was therefore not a statutory employee, and EQT is not immune from tort liability. In the matter of Scalla versus KWS, Scalla was injured when a chain hook lifting an excavation ripper broke, causing the ripper to fall and crush Scalla's leg, requiring an amputation below the knee. Scalla sought damages for his injury from KWS. Scalla filed the lawsuit and service was made on the sole employee of KWS in the United States. The employee signed for the notice but did not open the mail as she did not recognize the sender. Later, because KWS failed to reply, Scalla served KWS with notice of intention to enter a default judgment. That notice was likewise served on KWS's lone employee in the United States. The document also went unopened. Default judgment was entered against KWS. An email was sent to KWS notifying them of the same on March 27, 2018. KWS responded to the email and petitioned to have the case removed to federal court. The litigation proceeded in federal court and was ultimately remanded back to state court. At that time, in January 2019, KWS filed a motion to open the default judgment. To open a default judgment, the moving party must establish that the petition to open was timely filed, the default can be reasonably explained or excused, and that there is a meritorious defense to the underlying claim. Here, the court found that KWS failed to meet any of the 3 required prongs. As to prong 1, removal of federal court did not prohibit KWS from filing the petition to open the default judgment. There was no justifiable excuse for waiting 10 months before filing in state court. As to prong 2, the fact that their employee did not open the mail is not a reasonable or explained excuse. And as to prong 3, KWS filed only boilerplate reasons as their defense and failed to state with any specificity the meritorious defense to the underlying claim. The default judgment against KWS is affirmed.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.